Sealing the minutes?
Right.
Yeah, I'll
It's
do seal the minutes.
only a $250 application.
It's just, I left it on my desk.
I mean,
We've had a couple controversial cases, like there's one in Francis town.
We
Yeah, that
putting anything up on the,
They overruled.
Nope.
You
guys-
Yeah.
Guys,
Yeah, mine
they're
is reading
resuming.
out.
no?
Oh, I'm sorry.
Everybody ready?
Oh, aren't we missing?
We're here now.
Okay, so there's
There.
only two?
Yeah, Tyler's on the road.
Okay.
Good evening.
Good evening. No.
I'll be chairing the meeting tonight.
Okay.
So welcome to the select board meeting for the town of Peterborough on this Tuesday, April 19th, 2022 at 5:36. I'm Bill Taylor, chairing the meeting tonight. It's pretty important. With me is Bill Kennedy, Nicole McStay, and Ally Kreutz. And that's it. Nicole,
All right.
fire when ready.
Well, we have the one item on the agenda.
Right.
The select board has been asked to weigh in on the proposed zoning amendment to the Monadnock Healthcare District, or the Healthcare District. After some consultation with town attorney, been reaffirmed that the select board really has no power or authority to act on that amendment at this stage, that it is firmly in the hands of the voters to determine what its next steps are.
And we couldn't, if we wanted to, reverse any decision that the planning board made.
No, absolutely not.
We couldn't take it off the ballot.
You would not be able to take it off the ballot at this stage, no.
Anybody have any questions about that?
We heard from Phil Runyon that you do.
Don't forget to say your name.
Oh, I'm sorry, Sharon Monahan. I'm sorry, but we recently, Stephanie.
He did
Yeah.
not say that, Sharon.
Okay, never mind.
He did not say that. No, but,
Speak?
am I allowed to speak? Are you opening up? My name is Stephanie Hurley, and Joanne Carr is not able to be here, but she sent us a ruling or statement from the New Hampshire Municipal Association, which I will share. And I'd like to direct you to look at the, well, the first thing would be where it says the Secretary of State, down about 2 paragraphs. It says the Secretary of State will direct local officials on questions relating to elections and ballots. So that state officials may counsel local officials to proceed with their duties as set forth in the questionable enactment on the theory that a municipal enactment is presumed to be valid until it has been challenged. So I guess one of my questions, and I have a follow-up as well, is were you guys able to consult with the Secretary of State on this situation? I mean, you got the letter about why we're questioning that it's valid, right?
Mm-hmm.
That it was noticed and the meeting was held. When the meeting was held, when they brought it up, it was at a meeting that the public had been told that was the end of the public session. So it was at a non-public session that it was originally discussed. And then when it was noticed, the date of the public hearing was after the last date that you're supposed to have public hearings. So I just am curious if you have asked the Secretary of State for an opinion on this.
Well, we asked the town attorney for his opinion on it, I think, a couple times, Nicole?
Yes.
And
Okay,
he-
but not the Secretary of State.
No.
Okay. All right, so,
The Secretary of State's who sets the actual calendar, the municipal association has.
No, the RSA's, the state laws set the calendar.
Oh, okay.
And then whether it's town attorney or New Hampshire Municipal Association, an attorney will interpret those laws and set a calendar, or make determinations about whether or not a hearing can be held on such and such a date.
Mhm.
I think that this is actually pretty clear. If you read from the beginning of the last paragraph on this, local and state officials are willing to proceed in these cases because the courts have not always required technical perfection in the enactment of municipal ordinances in instances where challenges to these enactments have been litigated. As Peter Laughlin, Esquire, explains in his work, Land Use Planning and Zoning, New Hampshire Practice, et cetera, the New Hampshire Supreme Court has adopted the substantial compliance doctrine, which holds that minor deviations from the procedure required by an enabling statute will not always invalidate an enactment if there was substantial compliance with the legislation. In this case, we're talking about noticing for a hearing. Certainly the hearing falls very close to the end of the window, but within the window that you can hold zoning amendment hearings. Notice is intended to provide landowners who are affected by proposed zoning or amendment changes to know about and be present at those hearings. In this case, we certainly know that they were, since the CFO and vice president of the organization that owns all of the property within that particular zoning district were sitting in the front row of that public hearing. So certainly the spirit and the intent of that requirement was met by the planning board. And that was town attorney's opinion as well. So at this point, it's really up to the voters. If the voters choose to pass this ordinance and someone chooses to take it, and test that in the courts, they certainly have the right to do so. But at this time, it's really up to the voters to decide.
Okay, well, could I go on? Because I wanted
I'm sorry, I didn't mean to cut you off.
I actually wanted to look at the remainder of that paragraph where you stopped reading, Nicole.
Mm-hmm.
There are limits to this rule. If the defect serves to deprive the voters of meaningful notice of a proposed enactment or meaningful opportunity to be heard in debate, the enactment will be declared invalid.
Mm-hmm.
Each situation must be evaluated upon its own facts, but in general, if the defect is minor and technical, the enactment will probably survive. However, if the defect is such that the voters did not know they would be considering the issue due to lack of notice, or if required public hearings were never held, the ordinance would probably be invalidated.
Mm-hmm.
And I would say that that is the case. The voters, they did not have adequate hearing. When the voters actually were able to come to the hearing on the 30th of March, there was no choice. It was either a done deal or it would not get on the ballot at all. There was no chance for any changes to be made. So there was really no real public hearing, in my opinion. And this is, I think, if you guys want to leave it, that it has to be, the only way that it can be invalidated would be if somebody sued and questioned the procedure, then that is your right. If I were in your position, I would check at least with the Secretary of State to see if they also agreed that, that it's not your right to pull it off. At the meeting, I asked the CEO, do you feel that you will be able to build this project before a year? And he said no. So I said, why can't we wait so we can have a full public hearing and find out what the public feels? I am not against them building. I would like to see workforce housing required in the proposal for them, that they have to do some workforce housing, that they can't. The people in town are looking for workforce housing. They're telling us, the hospital is telling us, that the reason that they're doing this is because they want to fulfill their responsibilities to the community for the public benefit. And they say that they want to put in affordable housing. Workforce housing is not as strict as affordable housing. That's what I'm asking for. I want some, not the whole project, but a percentage. And I don't feel that this was adequately able to be vetted in the public. So I guess that's what I wanted to bring to you guys.
Well, I mean, even if we decided that we did want to add or subtract or pull it from the ballot, we don't have the legal authority to overrule the planning board, because they're an elected board, just like we are. So we can't overrule
Well,
what they've done,
actually,
no matter what might happen as a result of it.
I said that Phil Runyon didn't say that, but he said if anyone in town has the right to make a decision about this, it is the select board. That would be
Yeah.
the only board in town that could potentially take this off the ballot. He wasn't suggesting you do that, but he did say that you would be the only board. So I would just,
That would be adding something even more illegal to, if there's a problem with it in the first place. I mean, we just can't just pick and choose what stuff we pull from the ballot.
I'm not aware of an RSA that would allow you to do that, not, especially not at this stage.
Right. I mean, then what would stop us from pulling anything that's on there off?
Well, let me ask you a
It's
question.
Supreme leaders.
Let me ask you a question. Were the majority of interested parties at this public meeting that was held the day after it was supposed to be addressed?
there were only a few people there
The-
at the meeting that was after the final date, in other words, is what you're asking.
Right.
So the March 30th, there were some public there, and most of them also were concerned with workforce housing. So, you know, that's part of what that group wanted to see, was some request for a percentage of workforce housing in this development.
And
So this proposal, as it's going to appear on the ballot, you oppose it?
I think it should say workforce housing. I want them to be able to build, but I feel like there have been too many projects in town that the argument is any housing is good for housing. And I don't agree with that. People in town are asking for affordable housing. There has been no requirements for affordable housing in any of the developments, and unless we ask specifically for some workforce housing, and in my opinion, the planning board will have the right to give them additional density to compensate for the affordable units that they provide. So we're not asking them to not make money on the project, but we're asking them to, you know, come forward and do their due diligence for the town and not just build more expensive housing. People brought up Vale Street, I think, and said, you know, when they were first built, they were close to workforce housing price.
Right.
And now they're not. Well, that's because it's not required that they make it a permanent thing. And if the hospital is not asked to make it a permanent thing, I question whether they will. And they're doing this, they say, because of they have to do public benefit. So what more perfect time to put affordable workforce housing, I keep saying affordable, but affordable is harder to get because it's cheaper. It's less expensive, and so you could make less money on that. But workforce housing, that's what the hospital says they want. And I heard from some of them that, well, no, they don't want that because they can't afford it. But nowadays, there's all kinds of benefits from the state. They're trying. Everybody is, you know, the state wants more affordable or workforce housing. So there's a lot of loans and things that, you know, we can help them get and try to put some workforce housing in, and I don't feel like it's been vetted by the town. So if this goes through, what my campaign to the public will be, if you believe that there's not enough workforce housing and you want workforce housing in town, then you need to vote against this. But, you know, I'm just one person.
Well,
I don't know
let me-
how much effect I can have.
Let me ask a few more questions. I've had conversations with Lawlor and Rash about this subject. First of all, the hospital's role in this whole thing is they're making land available for building. They're not actually doing the building project themselves. It's going to be some other contractor, some other entity.
All the more reason to have it as a requirement.
Whether this passes or doesn't, isn't this, first of all, what effect does it have immediately And isn't it something that you could remedy in the coming year with increased conversation through the planning board?
Well, I would hope to be able to do that, and I agree with you on that. My concern is I don't like seeing things happening in town that really seem to go against the RSA's, the plain and simple, right in front of your eyes. I don't think that we should be doing stuff that looks to anybody who's paying attention like they're going against the law. And I don't like seeing the town do that. So for me, it's like, yes, we could work towards changing it and finding out if the people want this or not. I think that people want affordable housing, workforce housing. I'm not positive that they actually want it. I'm sure there's a large element that does not want it. But what better place than at the hospital? You know, than out there where there aren't that many, it's not a neighborhood so much and stuff. So yes, you know, we could do that, but they could do that too. So why was this pushed through? I mean, I was in a group that was trying to get the board to look at some, I think, important legislation having to do with innovative land use controls and really having them used properly. And we came to them in October and they said, oh, it's too late to get it on the ballot. We can't consider that this year. And they didn't consider it. And here it came on March 14th in a private session where nobody in the public had been told about it being developed. And then it was noticed as a public hearing after people could make any change, after there was any chance of making any change. I just don't think that that's the way that we want our town to be viewed, is that we do things like that it's against the law. So, you know, you make some good points too, but they could have also waited. And, you know, and I'm very upset with the planning board for not standing up for workforce housing, because I did make a huge long speech on the 14th about including workforce housing. And I tried to get them to do it, and they're like, well, no, we don't want to do that because we don't want to prevent them from building something. Who's going to stand up for the people in town who need affordable workforce housing if we don't?
I support
Valid.
you on that, and I was gonna ask Sharon, you are a member of the subcommittee of the EDA
Yes.
on housing.
I'm with the Affordable Housing Committee, and that before the public hearing, so that met on Monday, and the public hearing was on a Wednesday. And Ivy Van came to our meeting, and we had a very long, contentious discussion as well. And James Kelly we did not take a vote. Carol Nelson had asked us to take a vote on it because it was not resolved. And what it came down to was that they also wanted, why did they exclude workforce housing? Multifamily, but not. They wanted it to say workforce housing in the amendment, you know, multifamily workforce
The
housing.
EDA did.
Yeah, yes, the subcommittee
The
did.
affordable housing.
The Affordable
right.
Housing Committee,
Sorry,
they
yeah.
wanted a commitment to that. Ivy Van came and she went into her lecture of how you can't make housing affordable. And that she didn't want the hospital to be restricted. So it caused disagreement, you know what I'm saying, that here we go again. No protection to that this is going to be workforce housing, okay? So actually, that the hospital didn't want to be restricted. So there's this mindset, and so how we ended the discussion was, it's not restrictive. That's the whole point. You know, I have to explain that if you go under workforce housing, it's a conditional use permit, and you get benefits and you get bonuses. You know, so you know it's fighting this ignorance a lot. And the final thing, finally where the group agreed upon was if there was something, a commitment, if there was some legal thing, and they were saying that, I guess James Callahan is the attorney for the hospital, that the committee would support it if there was some guarantee in writing that it would be workforce housing. So at that
Not
time.
all of it, though.
No, just some workforce housing.
Okay, but
But at that time, so then we go to the committee meeting on the 30th, and we find out it can't be amended. So that's where, yes, the housing, you know what I mean? The Affordable Housing Committee is in support, but they wanted that amendment.
one of the things that I want to emphasize tonight is we're putting the hospital in as monkey in the middle, and they don't belong there. They are donating the land. Eventually, it's going to be some contractor who's going to build that property, and they'll have to come before the planning board, and the planning board can put those kinds of restrictions on them. Am I right or wrong?
I don't know. I've been told, before I got on the planning board, I was wondering why they didn't put restrictions on, and they said, we are not allowed unless it's written that it's workforce housing, that there's, and the workforce housing law on our books does not give you, it doesn't have to all be workforce housing. It can be a small percentage of workforce housing. It does not have to be all, but it has to come in under workforce housing.
The application has to be made by the applicant to build workforce housing in exchange for some density bonuses, sometimes there are setback bonuses and other things that could be considered under that particular piece of the zoning ordinance. But it's not, it provides them with benefits if they do so. They're allowed to build additional housing units, but yes, they have to be built to be affordable to a certain bracket of people.
Well, it's not my intention to litigate planning board content.
Well, unfortunately, we can't.
And it's our attorney who's saying, first of all, it was done legally, that's number one, and second of all, even if there's a hint that it wasn't done legally, we have no power to change it. So,
Not that,
my hands are
not
kind of
that
tied.
we're coming out and saying we think there's a hint of something wrong with it.
No,
Because, well, so, one second, Carol. What we're talking about here, what this letter is talking about, is the change for staff or students to multifamily housing. We're not talking about the original intent of the amendment, right? So when the original amendment was put forward, when was that, in the ballpark?
It was on the 14th of March.
The whole entire amendment?
Correct.
Well,
In non-public then it was proposed by the
Yep.
attorney.
It was posted on the 14th of March.
it was.
The entire thing, and then the change to it
That's
came.
the change. Well, the amendment is the change.
Right.
Okay, so what was the hospital zone part before?
It was for staff and students, as if you were to have multifamily housing within that district, it had to be only for people affiliated with the hospital, so staff or students.
And you couldn't get anywhere on the planning board getting them to add anything about workforce?
She tried.
Well, I mean,
And I know you don't have any power to make.
I would, I mean, that'd be great if we did, but it's a voting body, and if the recommendation, or if you made a motion to add multifamily or workforce to it, and it didn't pass, that is it's a vote of the planning board.
Well, one thing about that is I actually thought that we could do it the next time.
Right.
Because there was a public hearing, and I thought maybe, if we got some public that also agreed with that,
And by then it was too late.
and by then it was too late.
Exactly the date.
Well, Carol, what did you have?
So Carol Nelson, just to Bill's point about the hospital being put into the middle, I think that's kind of like what you alluded to, or which bill it was, I'm not sure.
It was one of us.
Yeah, one of the two. I don't know that I can agree with that, because if you look back at the minutes for 2 years of both the Affordable Housing Committee and the EDA, they had been talking about affordable workforce housing for 2 years. So this is not something new. This is specifically something the hospital has been talking about. So to have them talk about it for 2 years and then not have it come into the amendment is really disappointing and surprising to me. That you have this opportunity, the hospital does, because Jim Callahan came to our attorney and said, listen, we missed the deadline for a petition article. Can you do us a favor and bring this to the planning board, which they did in what I would consider a non-public session. Even though Rich Clark will tell you it was a public session, but there was no public there because they had closed it. So the hospital has had 2 years to bring workforce housing amendment to the town, and they didn't. That's my one comment. My other is I have questions on this SB town meeting deadlines. Nicole, I think you said it's an RSA that the state has for deadlines?
Let me back up. So the town of Peterborough is a charter form of government. For many things, we follow the SB2 calendar for the Maytown meeting.
Okay.
But not in all things. For most of the planning and zoning, it does follow the SB2 calendar.
Okay.
We typically, like many other communities, use the New Hampshire Municipal Association's calendar, just so we don't have to reinvent the wheel every year by examining all the different RSAs that come into play when you're figuring out dates for things. But again, like I said earlier, the New Hampshire Municipal Association's calendar is their interpretation of the RSAs. Just like any other attorney will have an interpretation that they're not always identical.
So I guess my question is starting with who creates them, and that's the RSA creates these broad.
State law created it. So the
Okay.
New Hampshire State Legislature created the rules that we have to follow
Right.
for all of the scheduling. Yes.
Okay, and they can be interpreted by a variety of people, it sounds like, but who enforces them?
The courts.
The courts. And so do you consider these deadlines arbitrary?
I don't consider it, it's not that I consider them arbitrary, because some of them are incredibly clear. They'll say must be, last public hearing cannot be held after however many days before the second Tuesday of April, or whatever it is, whatever the date is that's, being required.
Right.
New Hampshire Municipal Association is very careful when they draft their calendar. They're providing guidance for when you should hold your first public hearing. They do that for not just zoning, but they also do it for budget and bond articles. And they are always very careful to note in their calendar that you should have your first public hearing on any zoning ordinance before such and such a date, because that will give you a window of time to, if you need to, hold a second public hearing. But that doesn't mean that that's the last day to hold your first public hearing. That's just your last recommended day to hold your first public hearing on an article, on a zoning amendment. Your last public hearing, of course, varies year to year, but it's usually within a couple of weeks of the deliberative session.
Okay, so just so I'm clear, November 14th, the planning board had a closed session that was not noticed about this amendment.
You mean March 14th?
Sorry, March 14th. March 14th, they had this closed session about this amendment that was not noticed. And then March 30th, it came to the planning board, the public could not comment and make a change.
So my understanding is that there was a closed session, that the closed session was closed, and then they moved into the public session. The public session was reopened. In that public session, it was decided that the planning board would take up this proposed zoning amendment, and that a notice was put in the paper. And then that notice provided the required notification window to the public to be present at the public hearing if they had interest.
So that public meeting on the 14th, there was no public? That
happens many times. We have lots of public bodies meeting. I had a trustees of the trust fund meeting where they talked about, how you administer and how you oversee the wealth generation investments of millions and millions of taxpayer dollars, and I've never seen a member of the public attend one of those meetings. And I've been attending them for 10 years.
I know, I guess, Nicole, what the point I'm trying to make is, for 3 months, I sat, and other people did too, in public meetings with the planning board, creating what was going to come to town meeting. And this one,
Carol was
I'm
there.
not-
Carol was at the meeting on March 14th, and she was kicked out.
Right,
because
because
it
she's
was
not a member of the
non-public.
board. Right, I understand
And
that.
then we had the meeting.
I am not
So you can't say
trying
it
to.
wasn't a public meeting, it was a public meeting, because it was not.
I'm trying not to, I'm not trying to say that what was done was right or wrong, it was done legally. that is the interpretation. Whether, you believe that it sets the right image or tone or doesn't, it certainly met the letter of the law.
Okay, thank
That
you.
nobody ever said we were opening the meeting. I was there. So, it was not.
Peter?
Thanks, Bill. Mr. Chairman, so I've received the correspondence that you have and other people that have communicated with me, and I guess I'm concerned, not with the board, but maybe with your town council and interpretation of what I've heard from Nicole. One of the things with notification is not only for the property owner affected, but the abutters, so no abutters would have been given any notice for any discussion. And I've served on a planning board in the past. The planning board never had non-public sessions, at least that I was ever familiar with. And certainly the Board of Selectmen had non-public sessions for a variety of things, but is there going to be a letter issued by town council of his interpretation of this meeting, how it went around? Because you made a good point, Nicole, maybe it met the letter of the law, which I'm questioning, but perception is everything in government. And this board does a great job with perception, but I'm beginning to get concerned because I'll be very frank with you. I see and hear from a lot of legislators in Concord, and for years I've heard from other legislators what goes on in Peterborough, whether it's the problem we had with the town clerk, which we got the Secretary of State's office involved, whether the Attorney General's office got involved with the selectmen way back over electioneering, the loss of the money, the millions of dollars, which no town in the state has lost that type of money, not once or 3 times. And it really concerns me, and members of this group and others have suggested that maybe the Attorney General's office should get involved, even in looking at this matter. And I said, let's wait, meet with the board, wait and see what the town council says. But it's very concerning because there's constantly something that gets in the news that it just doesn't look right. And I think what all of us want is everything to look right, perception and legally. So I guess that's all I have to say. And thanks for the board listening.
Nobody, I don't think, wants the perception to be perfect than the people on this side of the table.
Right, exactly.
I'd certainly love that. But, I mean, so even if it were legal, which it's not, that we even just pull this from the ballot, isn't it changing it from 4 staff or students to multifamily housing? Isn't that a step in the right direction?
There's no guarantee that there's going to be workforce housing.
Nope, there isn't.
That's
There's
what
no
that's what
guarantees
we've
about
been
anything,
asking for
really.
2 years.
Yeah, I don't.
And it hasn't gone in front of the townspeople.
Well, you're right, and I just don't, I mean, this is a planning board issue. Loretta?
Loretta Laurinaitis. I have a couple of comments. I mean, first of all, I agree with what's been said so far. I have some real concerns about that non-public planning board meeting with town council, and with town council apparently espousing this zoning amendment for the hospital. I don't feel that that is his role, and I don't feel that that should have happened in a non-public session. And I feel like basically, I think that was a breach of the right to know law. Now, you're going to tell me that the attorney said it was fine and that they went into public session. I don't think there, from the notes, that there was anything from the minutes, ever anything indicating that they went into public session. And we were all told basically to leave, that it was not going to be a public session anymore. I also want to note that in the rationale for this proposal for multifamily housing, it says this proposed amendment encourages the development of housing while removing the burden on the town to ensure tenants are affiliated with the hospital in perpetuity of their tenancy. I frankly don't remember that being discussed at the meeting as part of the rationale.
Yeah, it was mentioned as one of the reasons
Why,
that they didn't want to go under workforce.
for that reason,
Yeah.
too. But this had to do with the staff, and that was still related to workforce.
Somebody has to keep
Right.
track of.
Well, I don't
Nobody
think that's a
wants
good
to evict
reason.
anyone because they don't work at the hospital anymore. That's essentially what it comes down to. That was one of the
But that
issues.
still doesn't address.
Or
porch
restrict
housing.
a number of units to anybody that might be able to live there or afford to live there by saying,
them to
you're
sit
not
up.
hospital staff, sorry.
So they have to sit empty, yeah.
Well, connect this one sec. I don't know that there's any evidence that the town attorney is espousing this amendment. He weighed in on whether or not the timing was legal or not. I don't think there's anything to suggest that he was in favor or not in favor of it. In your,
I wasn't there, so I can't.
well, right, so
say that. I'm
then
just-
I was
if we weren't there
I
and we
was
weren't
there.
able to listen specifically, then we can't say that the attorney was on one team or another. He was there to weigh
Right,
in.
I was there, and he and Danica had been approached by Callahan. He was the one that Callahan had originally approached, and he brought it to Danica.
Okay.
You know.
So he was a messenger, but he wasn't necessarily advocating for the change.
But is it, I'm sorry, Carol Nelson, is it traditional that the town attorney brings zoning amendments to the planning board?
No idea.
I mean, that's not copacetic, I don't think.
So what's the remedy?
Actually, we've had many attorneys weigh in on our zoning in the past and made recommendations. There's been, many studies
Because
of
they
our
did a
zoning
favor for the
ordinance.
hospital?
This isn't about it being necessarily a favor for the hospital or anything. It's just, an amendment was brought and the planning board did choose to take it up. They discussed it in a public hearing. That's what's under question. Was that done properly? And according to town attorney, it was done properly. The planning board was, asked to take up an amendment. The planning board discussed it. They chose to take it up. It was noticed. The public hearing was held. It was discussed in depth at the public hearing. The planning board chose to move it to the ballot. And there it is. And so now it's really, again, just to get us back to what we're really discussing, it's in the hands of the voters at this point to make a decision on it. Before no one else can do anything until the voters have made a decision.
Okay, so then can I ask, how do we not get into this scenario again?
I think it really is the planning board's decision. I think you need to, if you have a discussion that you'd like to have with the planning board, it's with the planning board.
I happen to agree with Peter. It does look bad. I think everyone here is here because it looks bad. But it's apparently legal, and there's nothing we can do about it. So,
I mean, you can look at it as it looks bad, but the way I see it, by removing for staff or students and adding multifamily housing, you're opening a window rather than closing one.
Bill? There's no,
I know there's no price point on it, but there isn't anywhere. I mean, I think this is still a positive step, whether or not it says, here's the income limit, which may restrict. I mean, if there's an income limit and a nurse is just above it, then they can't live there? Like I said, this isn't our topic to take up, unfortunately. It's the planning board, and, there's elections, and they have consequences.
I'm just repeating myself, I think, from what I said at the planning board hearing on the 30th, and I was very emotional. I think I'm calmed down now. What I do not like is that it doesn't look good image-wise for transparency. I do not like, because of the statute that Stephanie gave you,
thanks for coming.
that
Thank you for hearing
See you
us.
soon.
it's vulnerable to be procedurally invalidated, and it's vulnerable for 5 years.
Yes.
And that's what I don't like. I'm tired of the lawsuits, okay? And
Amen.
I'm tired of it, okay? And I don't think it was the planning board's fault. As I said, they appeared just as surprised about the surprise zoning amendment in private session as the public is, now. But I do not like that we are legally vulnerable. You have the opportunity, because any abutter surrounding the hospital district, whether they wanted workforce housing or they don't want housing up there, or any type of housing, whether you're talking about your two groups, okay? you know, they have, both of them are now on the same side. They can invalidate it no matter which way it goes by saying it was procedurally, you know.
Well, that's.
And that's what I'm trying to say. I'm
Yeah.
just saying, I mean, it's not, you're not only vulnerable, you're vulnerable to whichever way it goes, whether you're for it or not, you know what I mean? Or, you know, if you wanted it to be workforce housing and, you know, it just makes us vulnerable to lawsuits, and I'm just tired of it.
Everybody is.
Okay, just tired of it.
I certainly am. 100% tired of drama.
Okay.
Absolutely.
I just wanted to add to what Carol was asking. She was asking, how can we prevent this from ever happening again? And I would like to see that that you follow, that the town follows the calendar for the New Hampshire Municipal Association for SB2 towns. If the calendar had been followed, can I just finish, please?
We're not an SB2 town, Loretta. We're a charter town. And so there are a number of things that the SB2 calendar would fly in violation of the town's charter if we were to follow.
But if it had to do with planning and zoning, you've said that you...
We do
you're gonna
typically
come-
follow it because, again, it's better than reinventing the wheel. But there are a number of cases where we cannot follow the SB2 calendar because it goes against the town's charter, which overrides that in some cases. It's very, very complicated. I think if you were to try to start from scratch yourself and to build out the town meeting calendar, you would see very quickly that it's very, very difficult to interpret all of those RSAs and try to make some coherent sense out of it. I've done it myself when we did the first couple rounds with the charter back in 2008 and 2009. It was very, very complicated to build out those calendars. And ultimately, we decided it was just easier in some, but not all cases, to follow the SB2 calendar that the New Hampshire Municipal Association puts out. But again, that's their interpretation. An interpretation is not the law itself, not the piece of legislation itself. And for that, in this particular case, the town attorney provided an interpretation, and that's what the planning board chose to follow. Again, this is the planning board's action. They are a separately elected body. The select board has no authority over the planning board or their actions. The planning board has its own scope of authority that's been granted to them by the state of New Hampshire through RSA, and this is certainly well within their powers.
Okay, I'd still like to finish what I was going to say.
Sure.
And that was that since you do follow mostly the planning and zoning calendar from the New Hampshire Municipal Association, to really comply with that. And if the town had complied, it says here very specifically, Monday, March 14th was the last day to hold the first public hearing by a planning board on a proposed adoption or amendment of the zoning ordinance, historic district ordinance, or building code, if a second public hearing is anticipated. Since final proposal must be included in the warrant and posted by March 28th.
Exactly.
RSA 675-3.
Exactly. And so the if, that caveat is what is really important here. It's if you believe a second hearing will be required.
Well,
Certainly, if the planning board had felt that they would have needed a second hearing to make a proper amendment to this particular zoning amendment, then they would have had to wait till the next year. But they did not believe that it required an amendment. They moved it to ballot as it was. Which I know you were at the meeting. I don't have to tell you that. But, you know, for the record, that's what happened.
Well, for the record, also, I would say that they felt they had no choice, that they either had to agree to what was presented to them or not. That if they were to make any changes, yes, they would have to put it off to the next year. And they did not want to do that.
That was their choice.
And it was the majority of the board that said, that's what we're gonna do.
That was their vote. Regardless of how you feel about it, and that's not even anything for us to debate. We don't have any control over.
Well, I guess my one other point would be that I hope you give some feedback to our town council, that people were very concerned about how this whole procedure evolved, and that it doesn't feel like the kind of transparency that we want to have in our town.
Again, it's up to the planning board. But don't worry, we've asked him to weigh in on it, I don't know, 3 or 4 times now. And he hasn't changed his mind, which is almost comforting.
But asking him to weigh in and giving him feedback about how other people perceive that might be 2 different things. And I'm
Well-
asking that you give him some feedback.
Sure, going by the letter of the law and what people feel about it, are, not even on the same stage. But believe me, anyways, Carol.
Oh, I was just going to say, having been to a number of planning board meetings recently, you guys are definitely much more receptive to feedback and input than the planning board, so.
Motion to adjourn.
So for that, I thank you.
Can I ask a question about something else? I understand, I'm someone that in September and October, part of the public hearing process for zoning amendments, I came in September and October, I was on the agenda, and I proposed, and I thought that was coming to the ballot, and I'm not seeing it. Chapter 224, manufactured housing parts, that to eliminate sewer and water.
I don't know, it's the planning board again, you'd have to, I don't know,
That's not in the zoning chapter, so is that a different,
that's not, it's not in 245, but it is still land use.
it's still land use, so
Yes.
because they did not, even though they discussed it and were for it in October, because it didn't make the,
I don't know what
What
why they
happened
didn't-
or
I don't know
where it
why
got
they didn't
dropped?
move it forward.
I thought there was something.
I don't know. I haven't looked at the zoning ballot that closely, to be quite honest.
it's not on the ballot, that's why, I just assumed it would be, it was one of the first things.
Well,
It did start off the whole discussion about manufactured housing, it generated.
If you mean the ballot that was presented at the deliberative session, that didn't include anything that's gonna be on there about zoning.
Yeah, there's no zoning.
The new warrant
That was
does, the new
strictly
warning
done.
on the website, it includes all the zoning, so.
Yeah.
If something should be on there that's missing, check with Danica.
Yeah, I did, I'm sorry, I laid at it because it was just
Okay.
recently posted, wasn't it?
Yeah, we just posted it on
Yeah, and so
Friday.
I just now saw it and I went,
Yeah.
oh no, that's
If-
not on there,
if we
so what
made-
happened to that one?
Yeah, I mean,
This was
if-
way back in October.
Absolutely. If
And,
there was an
it missed
omission,
me a little bit because we did it way back in October, and yet the one that, after the date,
Yep.
you know what I mean?
it may have been just a mistake in the copy and paste when Danica sent the zoning amendments to Linda, and then Linda put it into the warrant. So you would have to talk to Danica just to ask her if that one was intended to go onto the warrant or not.
Okay, yeah,
I don't know.
I'm sorry. Yeah, I inquired just today
Yeah.
because I saw that it wasn't on there.
All right, and Loretta,
One more thing.
really?
I just wanted to say, really, yes, really. I just want to say that I do appreciate your giving people the chance to discuss this issue with you in public in this way. And I don't know if that's going to be a regular part of select board meetings. I know some select boards have a public feedback session in every meeting so that people can come and discuss issues that concern them. So I would encourage the planning board, the select board to continue allowing people to give feedback.
Well, unless something really
Raise
crazy
concerns.
happens in the next month, it's gonna be the same select board. At least for another year.
Which is good. I think the board does a good job. I think perhaps the issue, obviously, as you mentioned, Mr. Chairman, is a planning board issue, but I'm going to pursue this issue with town council. I hope he does provide a letter in response to the 5 signatories that you received, because I think at the very least they deserve that. And I think this whole process, as we've heard tonight, doesn't really pass the smell test with me, so. any attorney, as you know, and Bill knows, can argue either side of the issue and perhaps win, so,
Both sides of that, yes.
yeah.
I would like to, I don't know if we need a motion, but I really would like Radigan to respond officially, essentially, in some public way.
In terms of the timing question?
Yeah, in terms of the timing question and how he came about his decisions. I think that's a good idea.
Thank you.
And that may clear up a lot
Thank you.
Yeah.
of issues.
Joanne?
Thank you for addressing me. I was watching on live stream, so I caught much of your discussion. I appreciate,
For the record, your name.
Joanne Carr, sorry. And I do appreciate your taking the time. I just want to speak to the timing of the ordinance as being outside of SB2 towns and the calendar, and I'm not going to mess with the issues with the charter, but the purpose of having public hearings on planning board matters, as you probably know, is to address some of the outstanding concerns. While multifamily housing sounds like a great idea, planning issues come up as to what's the density, what are we looking at for access, what are the other related planning issues to simply just opening up to multifamily housing. Is it multifamily per single lot? Is it multifamily 2 or 3 units per lot? Is it a density of 6 units per lot? We don't know, and that's not resolved through this zoning amendment. So this is going to cause an issue when someone comes forward with a development proposal. There's no guardrails or guidelines or framework to which to implement this new ordinance. We support it. I'm very much in support of affordable housing, but what are the rules? What's the precept here? What are we functioning under? So that's the purpose of having, you have your initial hearing, you address some concerns as they come forward, you resolve the issues in your code, and then you bring it to a final hearing, and that's the hearing. They finally decide, is it ripe enough to come to town meeting for a vote, or do we need to work on it more? Which is why we spent the whole fall working on other issues to bring them forward to a preliminary public hearing and then a final public hearing. So that's the rationale, and I'm sorry if this seems mundane to, and not the select board's purview, but this is an issue that comes, it is a matter of town interest. And I think you should be very concerned. To me, it's sloppy, it's hasty, it's ill-conceived.
Yeah, well,
And
that opinion's been shared. And it's still, there's nothing we can do about it, and it was a vote by the planning board to bring it forward. That's it. So, was that,
Thank you.
so moving on.
We've got some old business, I think.
Old business, right. Do I have a motion to approve the minutes of March 15th?
I will
With
second it.
corrections.
With corrections. Actually, I have a question. There was a point made in there about the meals and rooms tax, and we
Yes.
were going to send a letter to Rich Yardy. You were going to compose a letter?
Yeah, actually, it was withdrawn by the governor.
Oh, that's
so I
right.
think
There was
that's-
no need
Yeah,
for
so
it.
it just evaporated as an issue.
Okay.
Yeah.
That was the only
Yep.
concern I had about it. We've seconded.
Do we need a motion to approve it? The minutes?
Oh, I thought you did.
No. I
I'll-
don't think
I'll
the chair's
make the
supposed to
motion.
do that. All right, I'll second.
Okay.
Tyler's not weighing in on it tonight.
We don't need his vote. Any other discussion about it?
No.
So,
All in favor?
Aye.
Aye. And you had some other
I
business.
have some other business. So one item that should have made it into the packet this week, and I'm very sorry that it was an oversight on my part. The EDA and the Greater Downtown TIF and then the EDA have voted in favor of expending Greater Downtown TIF funds towards the Mass Grant project in this fiscal year. And to do so just requires now a vote of the select board to do that, and you have Danica's memo.
Yeah. And this is a vote to expend grant money that's already been received.
Yes.
That takes a lot. I'll second it.
No, it's do it.
Oh, I move that we accept the proposal.
Or
The vote, yes, to make a vote to
allow
approve
them
the
to
use,
expend this money.
approve the use of Greater Downtown TIF funds prior to July 1 of 2022, because really the reason to do this ahead of the beginning of the new fiscal year is because there's such a very short calendar on this project, and all the funds have to be expended by December.
I attended both the Greater Downtown TIP Advisory and also the EDA. Had to weigh in on this as well. And it was pretty unanimous.
So, move and
Second.
second?
Okay.
Yeah.
Any more discussion?
Anybody want to weigh in on that?
Come on.
All in favor? Aye.
All right, and the next piece, this came up earlier today. I met with Colin Murdo, who represents Phil Mathewson, working on those projects up at Southfield. They, as you know, have the remaining approvals to purchase from the town. And they're running into a snag. There's some new staff. There's been a lot of turnover in the Attorney General's office, a lot of retirements, and a lot of new staff there. There was an understanding of how they would need to proceed to form a new condominium association for the future condominiums on what will be, if you're going up Southfield Lane, it's on the right-hand side, which is all empty field space right now. Because the existing condominium association really doesn't want to take on the burden of managing additional condominium. We would like to see a separate association created. So they've been working with the AG's office, gave them the understanding back at the beginning of this process that if they could get a sign off from the condominium association and the mortgagees to split the two sets into two different associations, they'd be all set to move forward. There is now new staff, the Attorney General's office, reviewing these things, and that staff person has said, no, I want to see an entirely new plan for a condominium association. I want to see what the layout's going to be. I want to see all the designs. I want to see the proposed documents, all of it in advance before we sign off on this approval, which is going to set them back many, many months. They will have to, of course, get the plan set together, and their engineers are already very busy on other projects. They can't just pull them off of those projects and get them started on this one. It will have to go through planning board. They don't expect to be ready for planning board until probably August. And then with, assuming a couple of months for AG review, they're not expecting to be ready until probably late fall, maybe early winter. So they would like the selectmen to consider extending the transfer of title to a date of on or before December 30th, 2022.
And we've already approved the sale
Yes.
of the building rights, not the property.
Correct.
We don't own the property.
We don't own the property, just the rights to build on it.
What was that date in December?
30th.
30th, thank you.
So I move that we extend the purchase and sale agreement to December 30th.
Second.
All in favor?
Aye.
Unless you had something you want to say.
No, you just extended it last meeting, didn't you?
Yes, yep.
And then the Attorney General's office threw this
I
other
know.
curveball out.
Wow. That's too bad.
Yeah.
It's very
But
frustrating.
they are working on the last two buildings in the first thing at Forrest, so that's good.
Unfortunately, this doesn't really set back their project because they were planning on redesigning that entire build-out anyways. So their intent wasn't to begin building until probably this time next year.
It's all work that was gonna have to be done anyways.
Yeah, but it's
The
just gonna-
Attorney General just wants to see it.
But it's
first.
going to cost them a lot of money to do this.
They were gonna
what
have to
they're
do it
asking.
anyways.
Yeah, they were gonna have to do it anyways. This really screws up their timeline
Oh.
as far as what work comes first, And it's gonna be a little bit of a
Change
scramble.
of seasons and
Yeah,
the whole thing.
exactly. It's gonna be a bit of a scramble, but they'll get it done.
This will delay us receipt of any revenue.
Yes, but we're not receiving any anyway, so it's not changing much for us. unfortunately.
And just because we're extending it, this is on or before December 30th, so if something magic happens, it'll be before that.
Exactly.
And we'll have that money for Christmas.
That'd be great. Either way, it's gonna be before April 1st of next year.
Right.
So, and we're already past the April 1st deadline this year, so as far as tax receipts go, it's really neither here nor there.
Not changing anything.
Yep.
Okay, is that it?
Good.
Motion to adjourn?
I second that one.
Guess we're all in favor of that.
I think so. Thank you.
Thank you.
Night, Carol.
Thanks.